Mike here from FTG. I'm here today to give you an update, not really on my case, it's kind of linked to it, but on the current standing of the Fourth Judicial Court and Judge Shore denying PENAC access to the courtroom to document my trial as we've asked. I've asked, and of course PENAC has requested. What this video is going to be about is, again, I'm going to lay out in a very detailed and chronological manner from start to end exactly the progression, and I'm focusing on, again, the PENAC and access to the courtroom issue. I'm not focusing on my case. But in here you're going to see both the progression of the request and the court's denial, and how they changed the rules 3 different times. I just received this morning from my attorney the copy of the emergency motion to the DCA, the District Court of Appeals, where we're asking a higher court to put a stay on Judge Shore's order denying PENAC access to the courtroom, as well as addressing their ridiculous requirements to meet new media, etc. You'll see all of it in here. A lot of detailed information. I encourage you to go through it, and I also encourage you at the end, if you're struck, if it reaches your heart, if you're upset or whatever, to voice your opinion. Leave comments. If you feel someone needs to be contacted, a letter sent, a phone call made, I encourage you to do that if you want, but I also encourage you to remain respectful. I'd appreciate that. Thank you very much. Stay tuned. I think you're going to like what you're going to see here. All right, everybody. The first date of importance is October 24th, 2014. On that day, we were scheduled to have a hearing on the motion to dismiss. Prior to that taking place, Judge Shore stopped everything because Mr. Thomas Covenant from PENAC was present and wanted to record the proceedings on behalf of PENAC. Mr. Covenant did have his press credentials around his neck and indicated he was with the press. Judge Shore stopped the proceedings, had his head bailiff go locate the current administrative orders in reference to media recording, and provided those to Mr. Covenant, ended up letting him record the proceedings, which is on my YouTube channel under motion to dismiss, and instructed him that in the future, should he want to cover future proceedings, he needed to comply with the instructions. So that's what you're about to see, is the first set of rules that were set forth. Okay, everybody. The next date of importance is December 1st, 2014. On this date, I had a pretrial hearing where we were just getting a new date to reschedule the motion, the hearing on the motion to dismiss. Not important. What's important is Judge Shore went out of his way to address the media issue with Mr. Friday, my attorney. Mr. Friday made it clear to Judge Shore that he didn't represent PENAC. PENAC was requesting to document my legal proceedings of their own interest and on their own behalf and their readers' behalf. But after making that clear, Judge Shore proceeded to give Mr. Friday a new set of instructions and asked him to make sure they were conveyed to Mr. Covenant, even though Mr. Friday made it clear that they weren't client attorney. So the new set of instructions is titled Media and Technology Coverage of Cases of Extraordinary and Public Interest. These set of instructions were entered on December 19th, 2013. This is for cases, as it says, extraordinary public interest. O.J. Simpson, Casey Lee Anthony, cases of that nature. They have a specific set of rules and instructions that you have to adhere to in those because of the high media requests and stuff of that nature. So that's what you're going to see next, and this is the second set of instructions Judge Shore has placed upon PENAC in order to gain access to the courtroom. I think it's very important to make clear here, all right? By Judge Shore, in my opinion, by Judge Shore issuing these set of orders, administrative orders, and saying this is what now must be followed, he made a judicial finding of fact that he was making my case of extraordinary public interest. because he is requiring PINAC to meet those requirements to gain access to document my legal proceedings. So I just wanted to make that note there because I don't think everyone really thinks about that. So this is the new set of instructions that PINAC has to read or adhere to. Enjoy reading. Okay, the next date of importance is December 17th. I had a pretrial hearing to get a date set for a rehearing on the motion to dismiss, which was denied. Not really important. What's important on this date is this. Jeff Gray from Honor Your Oath was present as a PINAC reporter, and he had his PINAC press credentials on, clearly displayed. What was interesting on this day is both my attorney and myself were seated at the defendant's table. We were about 6 feet, 8 feet away from viewing this personally. And Major Weintraub approached Mr. Gray, asked him, what he was doing. And Mr. Gray explained, PINAC reporter, I'm going to be documenting this. And he asked Major Weintraub asked to see his press credentials. Jeff showed them to him. He looked at them, flipped them, went around Jeff's neck and said, these aren't press credentials. You can't record. Jeff put his hands up in the air. His camera's on his chest. Jeff put his hands up in the air, says, can I sit down and observe it as a regular citizen? Weintraub says, sure. Jeff sits down, and here's the very interesting part. This is what I want you to hear and see. Major Weintraub goes over to Jeff. Now, Jeff is seated, made no fuss, no nothing, was very docile. Weintraub walks over to Jeff. Jeff is seated in the bench pew, leans over him and says, if you don't like it, you can get out. Just like that. And then he stands up and he walks away. The look on Jeff's face was incredible. Probably just as incredible as the look on my face. I'm not going to say nothing else about it. The next date we're going to talk about is this, January 26th. Mr. Friday prepares his package for both the Chief Justice of the court, as well as Judge Shore, as well as the media committee, as he's been designated to do as per the previous order for cases of extraordinary public interest. He had to do this stuff in order to get media credentials. So he prepares it all. I'm going to put it on here in just a moment so you can see. And he submits it to both the court and this media committee. And I believe the chair of the media committee is identified as Mr. Larry Hanna, which you'll see in the letter. So this is what Jeff turned into them to prove their media worthiness as set forth by the court. And you're also going to see the letter in reply from the media committee saying, hey, look, we don't issue media credentials for cases that aren't extraordinary public interest. Mr. Hoffman's case is not that. And we're not going to convene so we can issue credentials for a extraordinary interest case. And in fact, the committee, Mr. Hanna, went on to say, you don't need credentials. You should have unfettered access to the court. So that's unfettered access to the court, I should say. So it's very interesting. So that's what you're going to view next. You're going to view the submittal by Mr. Friday, and you're also going to view the letter from the media committee denouncing that PINAC needs credentials and denouncing that my case is of extraordinary public interest. So enjoy reading. Okay, everybody. So what you just saw was the package submitted by Mr. Friday on behalf of PENAC to both the Chief Justice of the Fourth Judicial Court and Judge Shore of the court, as well as the Media Committee, as required by the latest administrative order presented by the court. So that's what you just saw. Now, what you're going to see is a response from the Media Committee in response to the package submitted. Enjoy. Okay, so this is the Media Committee's response to Mr. Friday's submittal of PENAC's media credential application. That's a mouthful. This letter was penned by Mr. Larry Hannon. What's interesting here, and that I think is important to keep in mind here, this is the committee that the court required PENAC to submit to in order to get the credentials that it needs because of the court's requirements. In this letter, the committee is saying, as I previously explained in our phone conversation, the Media Committee does not provide credentials to media organizations covering regular everyday trials in the Duval County Courthouse. Our organization was set up to provide assistance when a case is declared a trial of extraordinary public interest. Since the Media Committee was formed, that has only happened in the two Michael Dunn trials. Had Marissa Alexander gone to trial, it would have also happened in that case. Miss Alexander settled before her trial began. And we anticipated it would also happen in the upcoming Donald James Smith murder trial. At the moment, there are no other trials designated as trials of extraordinary public interest. It goes on, but you go down here, it's important, it says, on a day-to-day basis, credentials are not issued because all news organization, whether it is the Times-Union, the Folio, First Coast News, or PENAC, have the right to be in a courtroom. Trial judges in Duval County have certain limitations that they can enforce if they choose. For example, an administrative order that limits the media to one still photographer and one television photographer in a courtroom. Therefore, if you show up to cover a trial and are the only media to be there, you have the right to cover that case. If you plan to take still photographs and the Times-Union also sends a photographer and the trial judge chooses to enforce the one photographer rule, then the two media organizations must reach an agreement on who will go in and shoot the photos with that organization that goes into the courtroom, sharing photos with the other media organization. And then it goes on and says if you want to discuss it further. Okay, so in real summation, this letter from the committee that PENAC was required to go to is saying, hey, two things. One, Mr. Hoffman's case is not one of extraordinary public interest. And two, because of that, you don't need credentials. You have a right to be in the courtroom. So, there we have it. Okay, everybody, so what you just saw was the letter from the Media Committee, and, it is what it is. Once Eric received that letter from Mr. Hannon, he sent an email to Judge Shore in the court, pretty much summarizing the letter and saying, hey, look, the Media Committee that you said we had to go to says that the Hoffman case is not one of extraordinary public interest. And secondly, we don't need credentials. PENAC doesn't need credentials to go in the courtroom and video a case, of everyday nature. So once the judge got that email, the email was sent on February the 3rd. On February the 12th, the judge issued a new order on my case, not an administrative order, general order, but a new order on my case specifically addressing order on videotaping, jury selection, and trial. And that's what you're going to see next. Okay, everyone. So here's the order that the judge issued on February the 12th, 9 days after receiving Eric's email. Order on videotaping, jury selection, and trial. It just talks about here receiving the email from Eric. Then it goes on to state, as previously ordered, this court ruled that PENAC will not be allowed to videotape in the courtroom to cover this case unless and until it obtained credentials from the Media Committee. On behalf of PENAC, Defendants Counsel sought an opinion from the Media Committee, which concluded in a letter dated January 28, 2015, that it would not provide media credentials to PENAC because the case has not been declared to be one of extraordinary public interest. Therefore, at this time, PENAC has no media credentials, has not yet been officially determined to be media, and has no rights to videotape proceedings in the Duval County Courthouse. Now, before I continue, I want to point out a couple real quick points. It says here, on behalf of PENAC, Defendants Counsel sought an opinion from the Media Committee. Okay, well, I hate to say that that's just a false statement. The reason PENAC went to the Media Committee via Eric Friday was because the judge required it to be done in the administrative order that he put forth that PENAC had to follow, the one titled Cases of Extraordinary Public Interest. In that, PENAC was required to go to the very same media committee that sent the letter that, in fact, the judge doesn't like the results of. Okay, so that's really interesting and telling. So let's move on. It goes on here, it talks about unless and until PENAC is formally determined to be qualified as media, it is subject to the authority of the presiding judge pursuant to Rule 2.451C1 Rules of Judicial Administration, which applies to use of electronic devices in the courtroom by others, talking about regular citizens. Again, all these rules are framed in the sense that the judge only has authority to do A, control the conduct of proceedings before the court, B, ensure decorum and prevent distractions, and C, ensure fair administration of justice in a pending cause. None of these actions or none of these control points are met in this case. Okay? The judge is using them as excuses without providing justification for them being applied in this case. It goes on to say, should PENAC qualify as media, then it must comply with the second amended administrative order, again, which talks about media rules. All right? All these rules are framed in respect of controlling decorum in the courtroom, ensuring there's no distractions, fair administration of justice in pending cause, just like that. The same thing. You can't have 25 cameras in the courtroom, sound equipment, wires everywhere. That is what all these rules are talking about, okay? But the judge is using them as an excuse to be able to control what cases he allows media coverage on. Now let's continue. Because this case has not been declared to be one of extraordinary public interest, Administrative Order Number 2013-08 is not binding. However, the presiding judge finds that the definition of media provided in such administrative order to be persuasive. Likewise, this court is even more compelled to apply a very similar and precise definition of media as set forth in an administrative order recently entered in Orlando effective January 1, 2015, which states that media is defined as the following. Now, before I go on to this real quick, I think this is kind of funny. I kind of summarize this right here as shopping for an opinion that you like or one that fits your narrative. They don't like everything else. The media committee shot down that my case was one of extraordinary interest, so that killed this order right here. And then says the judge talks about in that order how he likes the definition of media, but he likes this one in the Orlando court even better because it fits his narrative a little more. All right, so I guess we'll just shop until we find what we like to fit our narrative instead of looking for true justice, looking for true clarity, and looking for true accountability. So let's continue. Here it talks about what media it is. It's defined in this order in Orlando, January 1, 2015. It talks about traditional media, print channels, television, radio, etc. Then it goes on about new generation digital media where it talks about, what it takes to qualify as that. And even without even really a hard review, it is very evident both through the information submitted by PENAC as well as just a quick independent audit review of PENAC via available sources out there that it meets these requirements. Okay? So once again, all these are shot down by reasoning, investigation, and logic. It goes on to continue. It says the media committee's letter should not have implied that PENAC is media and that it does not need credentials and has an untethered right to cover a case in a courtroom. Instead, individuals must comply with Rules 2.50 media and 2.451 others and are subject to the authority of the presiding judge over his courtroom regarding the use of electronic devices pursuant to such rules. In addition, if the videographer is determined to be media representative, the policies and procedures set forth in the Second Amended Administrative Order Number 9202 would also apply in the case of non-extraordinary public interest. Once again, this is all a bunch of gobbledygook for talking about rules, controlling decorum, distractions, etc. Legal talk. It's got nothing to do with the application of this case and how the judge is twisting these rules to fit his narrative to bar a media source from covering tyranny, oppression, and corruption from the bench. Okay? And let me go to this point right here. It's interesting the judge finds it okay to slam the very same organization that he required PENAC to go to get media credentials. He in turn says they should not have done what they've done. I find that very interesting and telling. So we're coming to an end here. It says, therefore, this court finds that although PENAC representative has a right to attend the proceedings as any person from the public would, it does not have a right to film or videotape any proceedings absent prior permission from the presiding judge. Accordingly, it is ordered and adjudged that PENAC may. It's giving PENAC three choices here. It can attend the proceedings of a member of the public and comply with the same rules that prohibit the public from filming in a courtroom. And here I want to point out that is a lie, because there are no rules that prevent the public from filming in the courtroom. Okay, there are the very same rules that talk about controlling decorum, equipment, distractions, etc. So once again, the judge sees fit to lie in an official document. B, file a motion and attach evidence to persuade the court that it qualifies as media, given the definition that the presiding judge has set forth herein in the case, and that if it qualifies, then follow Rule 2.50, Rules for Judicial Administration regarding sound lights, etc., the Second Administrative Order 9202, and directs the directions of the presiding judge. All right, so again, this talks about following the rules. And it says, C, you can file a motion conceding that PENAC does not qualify as media, given the definition above, and requesting that the presiding judge just permit it to videotape only in this one case, while agreeing to comply with the procedure set forth in the Second Administrative Order. Again, the same rules. So it says PENAC shall file its motion no later than March 2nd, and if necessary, the court will have a hearing. So I know that was kind of long, but I really wanted to go through the points in that, and hopefully I wasn't too irritating. So there you have it, and we'll move on. Okay, everybody, so we just reviewed the order on videotaping jury selection and trial, and basically what Eric did in response to the order from the judge is he chose to go with option B, and he submitted to the court on February the 17th, 5 days later. He submitted intervener's motion to video proceedings for the purpose of reporting on the trial of Michael Hoffman, and that's what you're going to be reviewing next. Okay, everybody, so this is the intervener's motion to video proceedings for the purpose of reporting on the trial of Michael Hoffman. I'm just going to scroll through this slowly, and you can look at it and pause it as your leisure. It's basically just laying the groundwork on why PENAC is a news agency. And then these are all the attachments. These are the same attachments you saw earlier when Eric submitted the package to the media committee. And again, this is what Carlos sent. And then these are just attachments showing the traffic on the site, the comparison. So, and again, I don't think you need to see all this. I think you get the picture. Okay, everybody, so you've just viewed the intervener's motion to video my trial. Basically, it's just an application to the court to once again meet their standards of media. That was on February 17th. Let's move forward to March the 5th. What we have here is the court now changing the instructions and the rules once again. This would be number 4. And what's interesting about this is coming from the Chief Justice of the 4th Judicial Court, and that is Chief Judge Mark Mahon, M-A-H-O-N. This is an administrative order. This isn't an order on my case. This is an administrative order, and it's titled Administrative Order Number 2015-1, Definition of Media for Credentials and Coverage of All Public Judicial Proceedings, except those of extraordinary public interest. And that's what you're going to review right now. And it lays forth what is now required to become established as media. Okay, everyone. So here's the latest and greatest order, Administrative Order 2015 TAC 1, issued on March 5th, 2015 by Chief Judge Mark Mahon. All right, I'm not going to read this. I'm going to scroll through it. You can pause it and read it at your leisure. But I do want to point out 2 things. But first is first. Again, if you can't figure this out on your own, just pause it once you get to a space that you want to read. And that's by Chief Judge Mark Mahan. All right, the two things I want to point out on this are this right here. Whoops. At the very beginning, whereas recent requests have been submitted for permission to videotape proceedings by non-traditional, self-proclaimed news-gathering sources, which has alerted this circuit as to the absence of any expressly articulated definition for media in cases that are not of extraordinary public interest. I think this is very interesting. It's obvious to me that the court is talking about PENAC. And it's disheartening to learn that apparently Chief Judge Mahan has no problem providing false information in an order, just like like Judge Shore does. Okay, PENAC has provided on more than 3 occasions definitive proof they meet the criteria of media as set forth by the court, even though the court has changed the rules 4 different times. All right, point number 1. Point number 2, which I think is very important, I'd like for you to look at this down here. All right, this is the signature of the order, March the 5th, and then this is where all these orders, administrative orders, go to, and I'm going to show you the previous ones as well. All right, so there's all the judges, everyone here you can see. Now I want you to notice there's something missing right about here, all right? This administrative order was not sent to any of the news organizations that every other administrative order was sent. Let's look at the original administrative order in 2011. This is the very first order that Judge Shore gave to Thomas Covenant and said he had to adhere to. So, and you've already seen these, but I want to show you the comparison and how the court is intentionally hiding their corruption and the fact that they are violating citizens' rights on an open basis. Right here. See it, folks? Can you see it right there? CBS, Fox, WJCT, Public TV, WJXT, WJXX, WTLV, all right? All these people, different organizations. It's in this one, and this is the original administrative order, April 7th, 2011. Let's take that one away, and let's look at the next one. This is the second administrative order that Judge Shore issued upon PENAC, saying they had to adhere to. And if we scroll to the bottom of this administrative order, we will see that once again, it's sent to all the news agencies, advising them of what they're required to do to film. All right, so we'll close this one. And let's look at the last one we have here. This is the one of media technology coverage of cases of extraordinary public interest, December 19th, 2013. All right, and this is another order PENAC was held to the standard of. And let's look at the very bottom of this order, and we will see there's a judge's signature. That's the old chief judge, Judge Moran. And, well, what do you know? Well, right here, it looks like it was sent to every news agency out there. Okay? Again, explaining the responsibilities. The second administrative order, once again, all the news agencies. But let's look at the very latest and greatest document, the one where the court commits violations of the public's trust, violations of the public's well-being and interest, in that it usurps its authority and just issues a wide blanket, giving itself the ability to bar any media organization it feels, under whatever reason it feels. Are we going to send this to the local news media so they can see what's going on? I don't see it in here, anyone. Let's look closely. Nope, I don't see it anywhere. I have one question, Chief Judge Mahan. What are you trying to hide? All right, everybody. I also want to throw in the application that goes with the latest administrative order that you just looked at. This is what the court is now requiring PENAC and any new media to fill out to apply for any and every reporter that they want to cover in the courtroom. So I wanted to put a copy of this on there because it's very telling about all the information they want. They want to know background on every reporter, how much they make, how often they get paid, all this other stuff. So I think it was important for you to see this as well. So I'm going to put this on here next. Okay, everybody. So this is the media application that now PennAC is required to complete for every reporter that they want to get media credentials. I'm not going to read this. I'm just going to go through it slowly, or go through it so you can review it yourself. Okay, that's it. Okay, everybody. So what you just saw was the latest and greatest administrative order that was created on March the 5th. And again, this is my opinion, and I think the evidence supports my opinion, that this order created from Chief Judge Mahan was in response to our motion, intervener's motion, to finally get PennAC media credentials. The fact that, once again, PennAC had met the standard, they've got to change the rules again so they can deny them once again. And that was the reason for the new administrative order. So what you're going to look at next is the judge's order on my case denying the intervener's motion to video the hearing. And that was issued on March the 10th. So real quick timeline. February 17th, Eric files the intervener's motion. March the 5th, the court via the chief judge issues a whole new set of rules. And then 5 days later, Judge Shores now says, okay, well, I have to deny your intervener's motion because we have a new set of rules that you have to follow now. So that's what you're going to see next. All right, everybody. So this is the order on the intervener's motion that Eric filed on February 17th. It says Administrative Order Number 2015 TAC 01 entered on March 5th, 2015 defines media for the purpose of issuing credentials and coverage of all public judicial proceedings, except those of extraordinary public interest, and thereby supersedes any previous orders entered by this court. Based on the foregoing, it is ordered and adjudged that the intervener's motion to video proceedings for the purpose of reporting on the trial of Michael Hoffman is denied. All right, this was issued on March 10th, 5 days after Chief Judge Mark Mahan issued the new administrative order setting out a new set of rules on how to get credentialed. Again, this being the fourth set of rules. I am once again going to interject my opinion here, okay? It is my opinion that the new Chief Judge, Mark Mahan, has very clearly made himself aligned with the interests of Judge Shore by completing the new administrative order. So it is my opinion that Chief Judge Mahan has conspired with Judge Brent Shore to violate my rights and violate the public's interest and the public's rights by denying media access to the courtroom. This is my opinion. Okay, everyone, so you saw the latest order from the judge. He got his excuse to yet again deny PennAC access to the courtroom. Again, real quick, I feel the need to put it in here, in my opinion. It's my opinion that Judge Mahan now has conspired with Judge Shore to violate my rights. So, that's my opinion. Where we stand now, Eric Friday has filed a petition with the District Court of Appeal, an emergency petition with the District Court of Appeals to get a stay put on Judge Brent Shore's last order that you just saw, as well as to pretty much demand that the lower court let PennAC in and come to their senses. And that's what I'm going to put up next, and that's going to be the last document that I have. I just received it 2 days ago, and it's the latest of where we stand. My case, again, has been continued until June the 1st, and that is because of this issue that we're going to the DCA about Judge Shore and PennAC being denied. So that's what you're going to read next. It kind of lays out in a very chronological order in a lot Reader's Digest version of what I just did, but it's interesting stuff to read. I hope you enjoy. Okay, everybody, here it is. District Court of Appeal, First District. Emergency petition to review order excluding the press from court proceedings. I'm not going to read this. Like I did with the rest, I'm going to scroll and you can pause and read. All right, there you have it. All right, guys, we're here at the end. I know it took a while to get here. A lot of information. If you watched it all and went through it all, as tedious it is, I appreciate it. It shows you have what it takes to get down to the details and to understand something for what it truly is. And that's what I've tried to paint here, is lay everything out in a factual and a chronological order to paint a very clear picture. And it is my opinion that picture is this. Judge Brent Shore and Chief Judge Mahan are overstepping their authority and using their authority to violate my rights as an individual, to violate my rights as a defendant in that courtroom, and to violate the trust of the public and violate the public's rights by denying PENAC access to the courtroom. What organization will it be next? Will it be someone smaller, someone larger that wants to cover a more controversial issue? It should make no difference. It should make no difference if it's a reporter. It should make no difference if it's a citizen. That is a public courtroom conducting business of the public. Okay? And if anything, I'd like to make it very clear. I am the only person in that courtroom when my case is going on that is being prosecuted. The state is using tax dollars at its leisure to try to incarcerate me and take my freedom away. We won't get into my case. What's important is they're doing that and they're denying the very same source of their funds access to see what it is that they're doing with those funds and how they're conducting themselves. I make this point, and I make it as clear as possible. A camera does nothing but document what happens. It is unbiased. It doesn't have an opinion on one side or the other. A camera observes and documents what it captures. It is for us as intelligent human beings to look at that data and analyze it. I asked this once again. I said it earlier. Judge Shore, Chief Judge Mahan, what are you trying to hide? Why are you trying so hard to keep out media to cover some measly little trial that apparently is so irrelevant no one else is interested in it? No other media organizations. Yet you have gone out of your way now 4 different times to change the rules to prevent a news organization from covering what it has a right to cover. I think I've said enough. Okay, everybody, if you're still watching this, you're going to get a little bonus video here. This is the 4th Judicial Circuit's website. And if you just bear with me a minute here, if you go over to Administrative Orders And if you click that and then you go to search, type in here in the keyword media. And what this is a listing of all the administrative orders that has something to do with media in some way. What's important is, and these go in chronological order, what's important is the last administrative order listed for media rules is dated August the 7th, 2011. They don't have any of the last 4 administrative orders listed on their own website. Once again, I'd like to ask you, Chief Judge Mahan, Judge Shore, what are you trying to hide? Why do you keep on changing the rules every time PennAct meets them? I really appreciate your support. I really appreciate you taking the time to watch this entire video. I know it's been long. Thank you very much. Stay safe and get in the fight.